Hello, I'm Jason Smolen with Smolen Plevy, a law firm in Tysons Corner, Virginia. I'm here today to talk to you about wills, trusts, estate planning, and the importance of taking care of all these things for you and your family. The problem with people that don't have a will, there are really two big issues they have to deal with. One, it has nothing to do with tax. It's where do you want things to go? Most simply put, if you don't have a will, the state has laws that will govern who gets what. It could be exactly what you want, and it's kind of a good guess on what you would want, but it may not be at all what you want to do. Sometimes, amazingly, families with grown children have absolutely no planning. Even worse, sometimes young families with young children have no planning. The difference and the reason why that's even more important to deal with is forgetting tax and forgetting money and forgetting anything else, who's going to take care of the children? So when you have a younger family, they need to think about it very early, perhaps for different reasons than a family that's more mature and has more money. Essentially, if one of the spouses died, whether you have a will or not, the law will normally give it to the surviving spouse. That's not the problem. The problem is, let's say the parents go away on vacation, the plane falls down, and they have 3 young children at home. There's an aunt and uncle who think they are the best one to take care of the children. There's an aunt and uncle from the other side of the family thinks theirs the best. And then there are the grandparents who feel that they've bonded with the children the most and would be the right one. Well, if you don't say anything or give any directions, it's a custody battle at the worst possible time at anybody's life because of the tragedy of losing both parents. So that's so easily avoided in even the most simple will. So parents, whether they have money or not, have to have a will. You just should not be without one. I've had this discussion where people are absolutely deadlocked on who would get the children if they were to both die, and they don't understand doing anything is better than doing nothing. I have a great deal of faith in the judicial system, but no matter what happens, when it's a judicial system, someone wins, someone loses. And even if it is the right decision, it's very painful and painful for a family. It fortunately doesn't happen often, but it happens, and it's so easy to fix. Why leave it to that as a possibility? If you're having trouble making a decision, I guarantee you a court will have trouble making a decision. You get huge philosophical issues between parents, which sometimes they're in sync on and sometimes they're not, and that is, what's enough? How much do I want to give my children? When is it enough? More typical arrangements are when the children reach certain ages, we want them to get the money, but every now and then you have a husband and wife that don't see eye to eye on that. You have to discuss and help them negotiate between themselves to something that they can agree that's the right and fair thing to do for both of them. After we've worked through where do they want things to go, we have to work through what are the tax implications of it. And that's a very significant area of work. That's a very important area of work that is usually a lot less emotional, and it's what can we do to try to minimize estate taxes. And what we find is most parents, most couples, when it's couples, their biggest concern is taking care of the surviving spouse, especially if it's a first marriage with children. They will usually say, I want my wife to have everything, or I want my husband to have everything. Well, it's terrific and it sounds great and it's very comforting, but it may be the absolute worst thing you could ever do. Congress actually has a very subtle way of convincing you to do that and yet penalizing you at the same time, because you have an unlimited marital deduction, which means you could have $1 billion estate. If you give it to your wife, she gets it tax-free. Well, the government's going to be here a lot longer than we are. So when the wife dies, guess what? She is the only one that has the estate. The entire thing gets taxed, everything. If you had done any planning in advance, we could have set aside at least some amount of money on the first death and saved it from estate taxes so that the wife would, of course, have to pay estate taxes on her share and what she has left, but we could have held some money aside, and under current tax law, that could be worth easily $1 million in tax savings just by having done any estate planning. Because we're each given individually an exemption, a credit, an amount of money that we can give away tax-free, you don't want to squander that by simply letting everything go to a surviving spouse. Even on a $2 million estate to $4 million estate, which sounds enormous, but people ignore that they have life insurance, they ignore that they have a home, all these things get thrown into the pot. And under current law, if you have more than $2 million by the second death, and you didn't try to protect the first $2 million on the first death, you've made a very nice, generous gift of $1 million to the federal government that could have gone to your children. It's a complete waste. When it gets to finances, we have a lot of tools to protect the family, the couple, the children. There are so many variations, no one size fits all. We really try to come up with something that works for the particulars of a family. Gifting. Well, you can give $12,000 a year to anybody you feel like it. And if you have 3 children that are married, that's already 6 times 12. That you can give every year away, no gift tax, no estate tax. If they have children, you can start giving away to those children. So there are some families that give away hundreds of thousands of dollars every year. So it's important to think of a gift plan. In the end, failure to make proper estate planning can result in a lot of unintended consequences, money not going where you want it to go, going to the government, paying excessive taxes, having some very bizarre results. We had a client die. The children came to us to deal with the estate, and we found out that because this person had not made any adequate and comprehensive estate planning, the bulk of his estate was in a retirement account, and he left it to an ex-wife. It wasn't the mother of the children, and the children basically were deprived of the majority of their father's estate with the bitter pill of it going to somebody that he divorced. Because of tax law changes and because of changes in wealth, I recommend that wills be reviewed and trusts be reviewed every 3 years. Every 3 years we send out letters to our clients asking them to come in so we can review their documents, regardless of who prepared them. If we prepared them, we want to review them in 3 years. If someone else did it 3 years ago and they're clients of ours, we ask them to take a look. What's very good about wills, for example, they mean nothing unless you're dead. We can change them as often as you want. Getting your wills and trusts, it's not inexpensive, but the value of what you're getting done is so far in excess of what it costs. I don't even know how to, state it otherwise. It's just important to get done. This is Jason Smolen of Smolen Plevy. I've been talking about estate planning and the consequences of following through with an estate plan and its importance. If you have any questions concerning anything I've spoken about, please feel free to contact me. The firm's phone number is 703-790-1900, or you can contact me by email at jdsmolen@smolenplevy.com. Thank you very much.